SJC-10566, Commonwealth versus Salazar.
Ms. Belger, good morning.
Good morning. Amy Belger from Manolo Salazar. May it please the court. I'd like to discuss issue 1 in my brief, which is the sufficiency of the evidence showing deliberate premeditation of the killing in this case. I submit to you that there was no evidence that demonstrates premeditated deliberation, and for that reason, the verdict in the case should be reduced to second-degree murder.
When you say no evidence, what about that the victim is found in a different room than the evidence would support that the knife came from, and that the nature of the injuries, I think that beside the carotid artery, that there were 6 other knife injuries and a defensive wound. Wouldn't, based on Commonwealth versus Farley and other cases, that be enough to survive a required finding?
I would say not, Your Honor, because the fact that the victim is found in a different room and the nature of the cause of death doesn't tell us the story of how that happened, and there can't be a nexus between where the body is found, given the way that this killing was committed, and ascribing any intent to the person who inflicted the injuries. The distinguishing factors between this case and Farley are that in Farley, the jury heard that the victim and the defendant were up all night fighting, that it was a prolonged attack. There was a duration to the attack that the jury had as evidence to consider. In this case, we don't know what happened. We don't know where he was stabbed. He could very well, the victim, have moved from where initially this conflict broke out to where he was ultimately found. That is just information we don't have. The jury in Farley, in considering deliberate premeditation, they actually had factual evidence. These 2 people were up all night fighting, and that this was a prolonged attack. We don't have that here. We have no idea what the duration of the attack was. We do have the medical examiner saying that severed carotid artery, that's it. That was the fatal injury. If you don't get treated from that, you're going to bleed out and die. But we also have the medical examiner saying...
There are other stab wounds, right? How many?
Yes.
How many stab wounds are there?
Numerous stab wounds. I would say, I think there's dozens of stab wounds. There's a lot.
Dozens of stab wounds, and also there's no injury to your client, right?
He has an injury on his right hand.
Slight cut.
Yeah,
Slight
that's
cut
right.
on his hand. So does that matter?
Well, it's not a self-defense case.
I know, but does that provide a suggestion of premeditation, that we've got so many stab wounds and no action with no injury to your client?
I wouldn't say that it does, Your Honor, in terms of deliberate premeditation. The law focuses us on the proper analysis for deliberate premeditation, and nowhere in that analysis as to deliberate premeditation is it take into consideration how many wounds the victim has.
Well, the number of blows is an important factor in Commonwealth versus Whitaker, isn't it?
The number of blows may be an important factor, but in terms of what else you have in this case, the number of blows is an important factor, perhaps if we're talking about extreme atrocity and cruelty, if we're trying to decide whether the murder was committed with malice, if we're trying to decide other legal questions other than deliberate premeditation, I absolutely agree with you. But when we're talking about what is premeditated murder committed with deliberation, I would say no, it doesn't. And I don't believe that Whitaker stands for that proposition, although Whitaker certainly has its place in answering legal questions as to different levels of culpability when there's killings under the law.
Doesn't our case law say that premeditation can be formed in seconds? I mean, so just with all of the evidence together, I'm just trying to figure, I'm having trouble buying the argument that there is no evidence that there was premeditation here.
I think that's absolutely true, that premeditation could be formed in seconds. What I think is the sticking point for this case is we don't know what happened at all. We have a body we have a blood trail to the fire station, and we have my client asking for help at the fire station. We don't have anything about any seconds, no matter how short, okay, that would lead anybody to believe reasonably, beyond a reasonable doubt, that whatever happened here happened with deliberate premeditation. And I agree, if there's anything, I mean, you look at Farley, they were up all night fighting, there was a duration to, the conflict, okay, that's sufficient. We don't have it here. There's nothing here in terms of a duration, a timeline, or any fleeting seconds where any intent of any kind was formed. And I would have to concede that there were anything of that nature in the record, right, that the evidence perhaps was sufficient. But because there is nothing in the record, I submit to you that the verdict for deliberate premeditated murder was insufficient on this record. And
So does that mean, so whenever we have one of these cases where there are just two people in a room, and we don't have any sort of background, why they killed each other, you could never be convicted of premeditated murder then?
well, I think, we have these cases all the time where there's people in the room and, we don't know what happened, but we don't call it first-degree murder. We don't indict people for that. We don't
That's true?
present that.
I mean, are there?
I think so.
Is there any authority, I mean, you make a very interesting argument. Is there any authority for what you just have come up with? Because don't we usually focus on the weapons and the injuries to get there on these premeditated murder?
I think the authority for what I'm saying, and I don't think I've
For a
come...
case like this, I mean,
Yeah.
Give me a case that supports your position as opposed to one you're distinguishing.
I would say the cases that support my position are any case at all that comes through our courts where...
I just would like one. Just give me one.
I can't think of one off the top of my
So
head.
isn't that striking that you can't find one?
I don't think it is, because I rely on subtle law of what second-degree murder is. Second-degree murder is the absence of deliberate premeditation. So I would say every single case where there's no deliberate premeditation proven, so we therefore decide that it is a second-degree murder and not a first, because we have malice, but we don't have deliberate premeditation, is what this case is.
When you-
So...
Go ahead, please finish your answer, I'm sorry.
So I would say I rely on, in terms of a case, every single case where a second-degree murder is proven and not a first.
After you finish your argument on ineffective assistance of counsel and the intoxication diminished capacity issue, I'd be interested in your view, coming back to this deliberate premeditation issue on the 33E issue of the relationship between the maybe not the strongest deliberate premeditation case and the level of diminished capacity as it relates to 33E.
And you would like me to do
Well,
that after?
Do whatever you're comfortable with, whichever order you want to do it in.
I want to add,
Might as well do it now, so.
I will do it now. Under 33E, in the interests of justice, you have the authority and the discretion to look at everything, the overall, presentation of the case and decide whether, in the interest of justice, justice was done by the verdict that was returned in this case. And the error or the where the deficiency can be from, either of the lawyers in the case, from the judge, or just simply what is just. And I would say, if you look at, assuming I've failed to convince you that the evidence was insufficient as to deliberate premeditation,
Wait,
compare this case.
Before you move on, are you going to move on to the second issue?
I wasn't going to, but I'm happy to do that, and I can revisit the 33E
Well, I was going to
after I
ask,
do that.
before you move on to the second issue, I was just going to ask, was there an argument made at trial that first-degree murder shouldn't be in front of the jury? Did that come up?
There was a motion for a required finding of not guilty after, but I do not recall that, Your Honor, before the trial started, no.
or even after the evidence came?
Yes, there was, at that point there was, and that was denied.
All right.
You know, sorry, what motion for required finding or a motion that just to knock out the first-degree murder?
Required finding as to first-degree murder, deliberate premeditation, yes, there was. And it was renewed at sentencing again. She did, again at sentencing, renew her argument, her motion on that, and her argument was there was no deliberate premeditation due to voluntary intoxication, as a defense.
No, on the 33E, it actually might well relate to the issue of ineffective assistance of counsel, because Judge Wilkins finds, perhaps not crediting trial counsel completely, maybe that's too gentle a way to say it, that the defense attorney, the trial lawyer, was actually showing a lot of agility in balancing the issue of diminished capacity and not stepping on the defense of, I didn't do it. So if she's sort of hamstrung and can't really argue the diminished capacity as vociferously as the evidence would suggest, couldn't we maybe factor that into whether this is more consonant with justice for a second? Do you see the relationship I'm talking about between the two?
I do see the relationship, and I see that the struggle that Justice Wilkins had with this when we went through this in the Superior Court. I think another sort of 33E type, predicament here is it took 10 years to get, to the Rule 30 hearing on this, and you can see in the record why that isn't. There was just no need for that. That was absolutely unnecessary stuff that went on for like 6 years over this thing with the transcripts, and he ultimately fires, his attorney, and we end up here. But the passage of time and so unnecessarily, and what maybe needed to be done on that ineffective assistance claim, he certainly was prejudiced, I think, by that. And that was a struggle for everybody. And I think everybody did the best they could, trying to remember and trying to put this thing together. But certainly, he was prejudiced in forwarding that claim, I would say, over the passage of time. So under 33, I ask you to look at that too. And also, so in the interest of justice, you look at this case, you look at what that blood alcohol number was, you look at the way that he appears to have been acting or moving, and what he was doing in terms of getting to the fire station. He is an alcoholic. The record, I think, makes that very clear.
You say that. What in the record indicates that he's an alcoholic as opposed to somebody who drank heavily that day?
Well, you look at what his blood alcohol number was. You look at the physical acts, and the way he got from the scene to the fire department. You look at the fantastical account that he tells of what's going on, the way he dealt with the EMTs, the way he dealt with the nurse. And it's showing alcohol, but it's also showing somebody who's functioning with that number. And you look at the affidavit from Harvey Cohen that I put in on the Rule 30 issue, and the way Nancy Santana, the nurse at BMC that dealt with him, described that. And, under 33E, and, we look at this is a person who, was in a very, very alcohol-induced state.
Okay, so I
when
take
this
from your
happened.
answer that there was no evidence of his alcohol use apart from at the time of the killing.
There was not, other than, the way he presented and what his alcohol reading was. And, I do think if the jury heard that, and, Justice Wilkins even says, everybody pretty much lay people know that .08, you can't drive a car, right? And we're looking at, he's almost up at 3. And people know what that is. What they really do, even if, the trial counsel was right in the sense that, she says, I didn't put the evidence on of the, what the alcohol number reading meant, because I think everybody knows that, everybody, but I understand that.
Let's play with that. I
but-
mean, we're speaking, Judge Wilkins very carefully distinguished between the error in not offering the medical record, even after Judge Hinkle at sidebar asked about the medical records, and even after it was presented as the basis for the motion to suppress his statements. So it's a bizarre omission. You have a motion to suppress based on the intoxication. It comes into evidence there, and then at trial, nobody presents it, even though the judge asked about the medical records. I guess did not specifically ask about the the breathalyzer, just refer to the medical records.
It is an extremely bizarre omission. It is incredibly unfortunate and unfair to my client that he didn't have this evidence for his jury to consider.
But Judge Wilkins found that it was ineffective, essentially, to fail to offer the medical record, but that there was a sound strategic reason for not having Karen Grondin or some expert testify to that, because that would take away from the strategy of soft peddling the intoxication. Do you agree with that Do you agree with that evaluation, or do you think it was also ineffective for failing to explain to the jury the significance of that medical record?
I completely disagree with that outcome, and the reason is because I don't think on this record that it is manifestly unreasonable to adopt a strategy where you would not forward the best evidence you have of voluntary intoxication because you're worried about that fantastical innocence claim made by a man who's trying to remember or account for what happened with a blood alcohol reading like that. And even on its face, it's ridiculous. That is not a strategy that any responsible or competent attorney would ever adopt.
Are you saying that the trial counsel was ineffective for going forward with the third-party culprit as the primary defense, or are you saying that Judge Wilkins was wrong in finding that that was the primary defense?
I'm saying that Judge Wilkins was wrong, as far as I can tell, in finding that was the primary defense, although I think it gets tricky because I credit trial counsel where he doesn't, so I defer to him in terms of his findings. Okay. He is the fact finder on this, and he says that's what it is. So from there, I say, okay, if that's what you think her strategy was, that was manifestly unreasonable on this record in this case. And then, even though you're finding under, Safarian prong 1 that she was ineffective, which he did, under Safarian prong 2, absolutely, it could have made a difference in the outcome of this case if the jury had that evidence.
So put aside for a moment, it seems like it was a factual finding by Judge Wilkins that this was a dual approach and a soft pedal. But what's defense counsel to do? What's defense counsel ethically to do? I think it was Ms. James. She's got a client who wants to testify. He has a right to testify. Her whole closing and opening doesn't mention the diminished capacity issue. Doesn't he have the autonomy, the right as a human being to try and go home instead of say, hey, give me a life sentence and maybe I'll be paroled someday?
He most certainly does have that.
Can the defense attorney now just step all over that choice in the closing?
In the closing, I disagree that in the closing, voluntary intoxication and diminished capacity was not argued.
I read it twice. It wasn't what he argues. What she argues is that it explains the reason for the conflicting stories. Of course, he would be confused. His friend just got shot and he's impaired, but she doesn't argue that this lessens the capacity to formulate the intent to kill and to deliberately premeditate, that argument's not made at all.
Well, she certainly does to the judge in trying to get, the required finding, and the judge is saying to her, I can't do that. She almost doesn't even get the voluntary intoxication instruction because, the Judge Hinkle is saying to her, there's a paucity of evidence here that he was even intoxicated. She doesn't even, there's nothing reasonable about doing that. There is no evidence in the record that my client said to her at any time, you can't argue diminished capacity. She's arguing diminished capacity to the court. She's doing it.
I know, but what
she's just not doing it well.
I guess my question is more this. It's easy to say, and I hear where you're coming from, that this is incredible, it's fantastical and all that, but she's got this case at trial, and he's saying that he didn't do it. She can't just blow up that defense by putting in overwhelming evidence that he's so impaired that his credibility and testimonial faculties have to be dismissed. She's in a very difficult position and has to sort of thread the needle.
Your Honor, we have a finding by Judge Wilkins that she meant to put those medical records in, and she forgot, and that is, below the minimum competency of what we expect from trial attorneys, okay? So it was never her strategy not to use them. I think that really gets to your point.
That's clear.
And if Judge Wilkins is saying she meant to do it, she didn't decide to hold them back to preserve the innocence claim. She meant to put them in and use them and argue them. She forgot to do it. And, I'm with him up until that point. But then when he says it wouldn't have made a difference to the jury, prong two, we part ways. And I disagree with that finding, and I disagree with the finding that this wasn't manifestly unreasonable. And I do think, I know I'm out of time, but I just wanted to say my sister, raises a point which I thought was a good one that I need to just address briefly. She says, I spend a lot of time in my briefing here on the manifestly unreasonable part of this, more time in front of the Superior Court on Safarian prong 2. Not so much in my brief, but I did address it on page 45 very briefly with the Strickland site, that the issue is, once we accept Judge Wilkins' fact findings, that, it may have changed the outcome of the case, and I believe it would have.
Okay, thank you. Ms. Leary, good morning.
Good morning. May it please the court. Catherine Leary on behalf of the Commonwealth. With me today is the trial prosecutor, Assistant District Attorney John Pappas. Commonwealth respectfully requests that the court affirm the defendant's conviction for first-degree murder and decline to exercise its powers under 33E. I'll start first where we kind of left off with the ineffective assistance of counsel claim. Here, based on the facts of this case, where the defendant got on the stand and affirmatively testified that he did not do it, how Attorney James handled this in the issue of intoxication was actually quite skillful. A way to present intoxication and leave it for the jury without completely undercutting the defendant's.
Well, that assumes, it's hard to say it was skillful when she forgot to put in the most compelling evidence of intoxication. How strong do you contend the evidence was of intoxication without that blood alcohol and breathalyzer results? Judge Hinkle said it barely crossed the line to allow her to give the instruction on intoxication.
While there was not overwhelming evidence of intoxication, I do think intoxication was fully aired at trial. There was evidence about the crime scene, about the number of Corona bottles.
Well, yeah, let me stop there. I was young once. I had roommates. The sheer number of empty bottles does not necessarily reflect how long they've been there. Was there any evidence that those bottles were the bottles that had been drunk that afternoon? Or is that sort of the compilation of bottles they were going to bring back and get their 5 cents over the course of time?
Your Honor, I think it would be a reasonable inference based on the defendant's own testimony about the amount that they were drinking that day, saying we drank from about 11:30 to 4 p.m., and I didn't count the number we drank because we just drink and drink. And that was the defendant's testimony. And there's also evidence on rebuttal about from Santana, who was the translator at the hospital, about, yes, while the defendant was sluggish and bloodshot eyes and smelled of alcohol, he was still coherent. So it was fully aired, and it was put in front of the jury with the instruction by Judge Hinkle
I get
for their
that.
consideration.
Speaking of the rebuttal, you, Mr. Pappas, put in evidence that he had gone back to the scrub-a-dub at the end of the day, apparently after 11 to 4, I guess. What was that evidence, and what was the intended takeaway from that evidence?
That evidence, I think, perhaps was to discredit the defendant's account of events, that he had been sleeping on the couch or fallen asleep around 4. I think perhaps, I'm not entirely sure the point of that evidence, to be quite frank, Your Honor.
But I mean, in your brief, you argue that it was put in part to demonstrate that he was not so inebriated that he wasn't able to do something and go to the scrub-a-dub, and that there was something that happened there. I'm just trying to figure out whether the purpose of that was to say, well, he wasn't really as drunk as...
I think that was definitely part of the purpose. Of course, the Commonwealth, once the issue of intoxication was fully aired by the defendant's own testimony, the Commonwealth was entitled to rebut that and show, which the Commonwealth did, argue in its closing why the jury should find that there was no debilitating intoxication, which, quite frankly, Attorney James, deciding to highlight the innocence defense, did not argue in her closing, but the Commonwealth did address it and why the jury should find that he didn't suffer from debilitating intoxication.
So what do we do with the fact that the most compelling and scientific evidence of intoxication was not put in for reasons that we can't understand?
Even if this court finds that was error and negligent and fell below what an ordinary valuable lawyer would do, there's no prejudice here because there's no claim that counsel was ineffective for not putting in expert testimony to explain the effect of that blood alcohol content level on the defendant. Without that evidence, expert evidence to explain that for the jury, they would, as Judge Wilkins stated, the jury would be left to speculate how that would affect the defendant in his mental capacity.
So why was it not ineffective to put in something without that the jury wouldn't fully understand its measure? I mean, I know that the finding was that it would put too much emphasis on it. But why is that inconsistent with the innocence defense, since what he said was wholly inconsistent and made no sense? I mean, he's going to have to deal with the fact that he told 3 different or 4 different stories, so it's not as if he had a consistent story. Why would the fact that he was drunk be inconsistent with saying he was all screwed up when he told these stories, so don't think he's lying, just think he's drunk and confused and upset?
Well, this is what defense attorneys face tactically when you have a defendant, as Jeff Slowey noted, who wants to testify and they want to say that they're innocent. Those two, intoxication would necessarily admit that you did it, and you would at best get some type of involuntary manslaughter, intoxication, or second-degree murder, opposed to an outright not guilty. And so I would say to Lang and Pagan, which are cited in my brief, that where you have an outright not going for a not guilty verdict, even if there is evidence of it, you have to make a choice, and that's not unreasonable here based on the testimony in this case where the defendant got on the stand and said he did not do it. To undercut that, I think we would be here arguing differently if there was a forceful intoxication defense put forward in light of this testimony and those two inconsistent defenses.
What about Commonwealth versus Montron? What do you say about that?
I think Commonwealth versus Montron is completely distinguishable from this case. In that case, the claimed defense was an accident. So the defendant there necessarily conceded that he shot and he just didn't have the required intent. So therefore, intoxication and whether he was able to form the intent would have been very important to that analysis and wouldn't have been inconsistent or undercut that. Here, and the defendant did not testify there. Here, we have the defendant who got on the stand and said, I did not do it. So the issue wasn't necessarily intent at that point when that's the main defense, and that's how it was argued by Attorney James.
If I can turn you back to the inconsistency between intoxication and the defense of innocence, what is a competent defense attorney supposed to do with the fact that there were, 3, 4, 5 inconsistent and arguably bizarre explanations of what happened?
I think exactly what Attorney James did here, which was, you heard that he was drinking and that he kept drinking and he didn't count. That explains why he's fuzzy on his memory about what happened. I think that's what you have to do here in light of his testimony.
Would that be much more persuasive if you had a .258 reading in the evidence? I mean, that would provide some explanation of why he's so incoherent, wouldn't it?
I don't think so. No, Your Honor, I don't think so, because for the reasons I stated, that would leave the jury to speculate. As the jury could even know through their own common experience, people react to alcohol at different amounts. So the reading could be much lower and somebody could be just as incoherent, or the reading could be higher if they're able to function, and they could be completely normal and not have the alcohol affect them as much. So no, I don't think that would help.
That's a pretty big hit, 2.58 or whatever it is. That's, I mean, almost everyone's going to know that's really heavy drinking, right?
I think people would be able to know that it was about three times legal limit for drinking, but then again, here, without expert testimony testifying about this effect and cross-examination and how it could affect this defendant, I don't think it's helpful, and it would leave the jury to speculate. And this court in Commonwealth v. Cruz said that.
Do we have a factual finding, though, don't we, that from Judge Wilkins, that the defense attorney, the trial attorney, decided not to call, I forget how you say her name, Ms.
Grondin?
Grondin, thank you, decided not to call her. Isn't that a credibility determination that was made?
That is a credibility determination that was made, and in fact, in the third affidavit by Attorney James submitted, I think after the amended decision, she even states so much in that it was a strategic decision not to call Ms. Grondin, albeit for different reasons, and Judge Wilkins doesn't necessarily credit that. He kind of, even if we assume that's true, he goes on the prejudice analysis, but he doesn't credit that per se. But he made a credibility determination before based on her hearing at the testimony and the affidavits and the trial record.
Can you address the premeditation and give some examples of cases where, I mean, we just have no idea what happened. I mean, we know what happened in there, but we don't know what started it or why, or whether it was, they're screaming at each other. Just good cases for us where premeditation is found based on this kind of evidence?
Your Honor, I mostly concentrate on when I was looking for cases, I concentrated on number of stab wounds, and as court we've discussed, Farley is my best case on point. I understand there was additional evidence about what had happened leading up.
So Justice Lowy points out that the knife is brought from a different room. That sounds relevant. And the number of so that's what we have for premeditation, really, the number of stab wounds, the absence of injury, and the fact that the dangerous weapon is brought in from a different place. Is there anything else we can draw on for premeditation here?
I think correctly, the number of stab wounds that he traveled up the left arm and a direct hit to the neck, a very sensitive area. The inference that it was a knife that was carried from another room, as you noted. And I think also the fact that the knife was bent, it shows a lot of force was used. I would point to Commonwealth v. Hill, which is 387.
Commonwealth versus what?
Hill, Hill, 387 Mass 619, Note 7. It is an old case, but it's still good law, and I'm happy to send a 16L letter. I found this in preparation for oral argument. But there, the defendant was convicted of second-degree murder, but an issue in the footnote was whether or not it was sufficient for the case to go to the jury on deliberate premeditation, and they said 2 stab wounds with a direct path to the heart that showed considerable force was more than sufficient for it to go to the jury on that. And I think that's very comparable to here. I can't remember the exact details leading up to the murder in that case.
Logically, I'm just trying to understand that. So, I mean, we've got all those provocation cases. You lose control of yourself and you stab the person hard. So why is that premeditation force?
It just says it was so forceful. It was 2 stab wounds, so forceful, the direct path to the heart. That's what the case said. And I think here, where it's going to a carotid artery or sensitive part on a human body would show.
But we've never come right out and say, okay, when you've got this kind of violence, that's enough to get to the jury on premeditation. We haven't said that directly anywhere.
Not that I found, but to be quite frank, Your Honor, I did not research cases for that, for that proposition. But I think here, based on the number of stab wounds, the fact that the inference is that the knife was brought from a different room and that it was used with such force that it bent, that would, in light most favorable to the Commonwealth, that would be sufficient for deliberate premeditation.
And I mean, I gather this is not the kind of knife that anybody who knew what they were doing would use to kill somebody. I guess it's a kitchen knife, right? It's a serrated kitchen knife?
Yes, it appears to be in its Exhibit 58 and photographs of it are Exhibit 57. It was a 5-inch blade, serrated blade. But as Justice Budd noted, deliberate premeditation can be formed in seconds, and it can be proven by circumstantial evidence. So the fact that this is not a cleaver or a huge knife, like an extremely huge knife, I don't think bears on finding against deliberate premeditation.
Does the cover-up, does that provide some, meaning the explanations that make no sense, and does that help satisfy the premeditation requirement, that he's not coming forward and saying, hey, he accused me of,
I think it's definitely relevant and could be used by the jury as additional support for premeditation, that he fled. And if he really thought that somebody had come in and attacked his roommate, he would tell people at the fire station, at the hospital. He never did so. So that's all relevant. And to go to Justice Lowy's question, I believe it was Justice Lowy, about whether or not where you have this type of deliberate premeditation evidence with 33 review and intoxication, I would just point the court to Commonwealth v. Burgess, which is cited in my brief in the 33E section. And there was evidence of intoxication. The defendant was very young, had lack of education, and had stabbed the victim. And that wasn't a reason, based on fleeing from the scene was a factor, there wasn't a reason to reduce the verdict. And I think here it's obviously not exactly the same because every case is different, but
Was that a first-degree murder conviction?
it was, Your Honor.
I guess, Ms. Leary, my point more specifically is, let's say that you get over the rail on deliberate premeditation. You barely climbed over it. You didn't leap over it in a single bound. And then, again, say that you're right based on Judge Wilkins' findings that it wasn't ineffective to inadvertently not put in the strongest evidence on intoxication. There's still enough evidence in the record, as you've pointed out, that he's been drinking pretty heavily. Why is it if you have a really weak deliberate premeditation and you have a voluntary intoxication that you really can't take out for a ride because you got to be careful, why isn't the second degree more consonant with justice?
Because I think here you can look at the evidence, which was also argued by the prosecutor in closing, to show that the defendant did not suffer from debilitating intoxication, which is the standard. He was able, in the middle of or at the very end of January, to scale down from a triple-decker porch and then able to run across the yard, scale up a chain link fence, and go directly to the fire station. And I think that showing his ability to do that, even if this court looks at Dr. Cohen's affidavit, which I submit that you should not because we objected to move to strike, and it's uncross-examined hearsay. But even if the court were to consider it, because Judge Wilkins denied our motion to strike, if you look at paragraph 9 of his affidavit, he says that it appeared that based on the defendant's blood alcohol content level, that he was in a confusion stage, and which would be not having coordination, slurred speech, difficult comprehension. And based on the defendant's actions, he was, I think, arguably coordinated to be able to scale down that third-floor porch. Santana, who interacted with him, said he was slurring a little, but he was giving appropriate responses. She could understand him. I think the fact that he tried to attempt to cover up the crime, that speaks to, right immediately after that speaks to his mental state. So I think here, in this case, there's not a concern about this, a second-degree murder conviction being more consonant with justice on that evidence.
Does the debilitating intoxication go to the issue of intent to kill, or does it go to the issue of premeditation? I'm trying to think. I know that we've used the term, and I understand it in the context of whether or not there was malice, but here it's the issue of whether there was deliberate premeditation.
I think my understanding of the law is that generally voluntary intoxication goes to your specific intent, so as to malice. However, I mean, even here, the judge gave the instruction that the jury could consider it not only specific intent, but also on deliberate premeditation. So the jury had that. And this court shouldn't sit as a second jury, where you have, based on all this evidence, that they could find that he did not suffer from debilitating intoxication.
So what are we to make of his strange way that he exited the apartment? I mean, the whole thing is very strange. If he did kill him, he could have gone out the front door. What are we to make of that in terms of evaluating the totality of the evidence here?
Well, I think you could look at it the way I have just argued, or even if the jury had viewed that, or you could view that as evidence of intoxication, and along with all the other evidence of intoxication where they had the instruction, it was for them to determine whether or not it basically said that he didn't have the capacity to form the specific intent.
What I can't tell is what other investigation was done here. Do we have anything other than the individual describing the crime scene and the fact that he went to Scrub-a-Dub at 4 p.m. that day, and his going to the fire department and then later going to the Boston Medical Center? Is that basically the entirety of the case?
I believe that they also looked for his roommate to see if he had been home, to confirm or deny if he possibly could have been a culprit. I'm not sure I entirely understand Your Honor's question.
Well, usually there's other forensics, there's checks of cell phones, there's interviews with neighbors.
There were interviews with neighbors who asked if they heard anything. The neighbors that were interviewed were on the first floor, and this apartment is on the third floor, so they might not hear anything. There were forensic evidence. Crime scene came and combed all the blood stains in the house as well as to the fire station. There's forensic evidence from the BPD criminalist that showed a knife imprint on the defendant's shirt, showing that he had done it. There was Dr. Floenbaum's testimony about the defendant's wound, and that it was consistent with being caused by the murder weapon.
Was there any discussion with regard to the carotid artery cut as to how that was inflicted? Was it, I mean, any inference that can be drawn from Floenbaum's testimony about that?
I think where the carotid artery is cut, the inference is that the defendant's attempting to kill somebody.
Right, but I mean, was there any inference that it was a stab wound as opposed to a slicing wound, or as to the context, was there anything that we can infer from that testimony about the nature of his infliction of that wound?
I have one moment, Your Honor. I believe it was a deep wound. I can't recall from the record off the top of my head, Your Honor.
Okay, well,
My notes are not that detailed.
record will speak for itself, and we'll take a careful look at it.
Thank you.
If there are no further questions, thank you.